Hello everyone and welcome to today's Mondac webinar in association with Active Mind Legal. Our expert speaker will provide an in-depth exploration of the anticipated UK AI regulations, insights on how the EU AI Act affects UK businesses, and discuss practical strategies to navigate the regulatory landscape. My name is Dan Sampaio and I'm joined by a brilliant speaker to take us through today's discussion. Evelyn Sorensen specialises in national and international data protection law and supports her clients across all industries. Her area of expertise is particularly in the legal support of national and international corporations in the introduction and development of new digital business models. Before we begin today's webinar, a quick housekeeping item. You are able to submit questions to Evelyn by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to get those questions in. It's now my pleasure to hand you over to Evelyn to begin today's session. Thank you.
Yeah, thank you, Dan, for the introduction and welcome to today's webinar. I'm happy or pleased to talk to you about navigating AI regulations for UK and EU compliance for business. I will focus mainly on, obviously, the UK side, but will also give you a brief overview of what you have to expect when dealing in the European Union. Let's start with an agenda. So, as I said, I will give you a brief introduction to AI regulation landscape in the UK and EU. Then I will focus more deeper into the current regulation in the UK, the framework we have here. What are the implications of the EU AI Act for UK business? Then AI and data protection law, because this is one law that will affect you heavily when you do AI or when you use AI systems, when you develop AI systems, etc. And then last but not least, give you some practical solutions for compliance and accountability. So let's start with a brief introduction to AI landscape. AI is posing significant challenges for regulators, and we will see that there are different countries taking divergent approaches. Obviously, there are a lot of challenges and opportunities with AI. Let's start with some advantages. The benefits are efficiency, automation. They reduce AI systems, AI technology reduce human efforts and boost productivity. They might also enable better decision making, analyzes big data for smarter insights. You can do more personalization, enhance user experience. Just take Netflix and Amazon as an example. Other advantages are benefits in healthcare. AI can support with diagnosis, transportation, freight management can be enhanced. Also, education can be supported by AI technologies like lessons planning, lesson scheduling, customer service. Obviously, you can improve or make sustainable products with the help of AI. But there is a downside as well. There are disadvantages or challenges such as job losses because automation may replace human workers. Here it could also lead to disproportional effects with some groups, for example, gender pay gaps, especially clerical work is often done by women, and if it is if it's removed by AI or those job losses are caused by AI, we can have gender pay gaps. Bias and ethics problems. AI can inherit unfair biases. This can lead to discriminatory outcomes. I can come up with an example from the Netherlands. They used AI systems or AI algorithms for visa applications, and it was clear, or it was becoming apparent that those algorithms had potential biases. So visa applications didn't go through even though all the criteria were fulfilled. And it could also lead to high costs because obviously it's expensive to develop and maintain AI systems. Next, I will focus on AI ethics and governance and regulation, just to give you a broad overview until I get deeper into. So obviously, AI is developing extremely fast at the moment. They shape our daily life, they shape our decisions in certain areas. In the UK, we have no AI specific laws at the moment, but other laws like the UK GDPR impact the use of AI to quite extent, especially when personal data is used or automatic decision making is in place. So there are certain restrictions placed on AI systems and technology by the UK GDPR, the Data Protection Act. On top of this, you have consumer and competition law that might have an impact on the use and development of AI. Intellectual property law, such as copyright issues, are also affecting the use and development of AI technology. But at the moment, there is no general statutory regulation of AI in the UK. There is an innovative strategy in March 2023, and this has been updated in 2024. The UK released a white paper on responsible AI growth. I will go into this into more detail to explain you what the proposal is stating and how it will affect your business. And it is the first step towards a framework around responsible use of AI technologies and systems. So it's more a non-binding approach. If we look at the international perspective of AI, the European Union has chosen a completely different approach. In the European Union, there is the EU AI Act that became effective in August 24, and this classifies AI by risk with legal rules and high financial penalties. So it's a completely contrast to the current UK approach. The EU takes an active regulatory approach and categorizes AI use into risk, which impose legal obligations on users, developers, producers, etc. And as I said, also enforces high financial penalties for misuse. The United States is used an industry-led approach with federal agencies adhering to key principles for responsible AI usage. And then we have a global collaboration where the UK is also part of. It's the Bleachley Declaration on AI Safety. This is an international agreement that has been signed in November 23, where 28 countries and the European Union committed to collaborative efforts in ensuring the safe development and deployment of AI. And they particularly, or this agreement particularly, focus on frontier AI risk and global governance frameworks. And as I said, the UK has also signed this. So there's a lot of regulatory approaches going on. You need to keep yourself up to date, as you will see in the course of this webinar. So let's move to the current regulation in the UK. The government is facing several questions: how to regulate cybersecurity risk posed by AI, how to spread or how to fight the spread of misinformation or disinformation, and how do they actually, or how should they actually take control over decision making. So the question remains open as whether there will be an impact on UK if other countries like or regions like the European Union set global standards, how to respond to this. And so far, the white paper on the regulation of AI is not a horizontal approach, but a principle-based framework. So the UK decided to balance innovation with safety in AI development. The approach is there are existing laws. I mentioned already the UK General Data Protection Regulation, intellectual property law, consumer and competition law, but there is at the moment no new AI specific legislation. So you have to navigate through the legal landscape, the existing legal landscape, to see how those laws are affecting your AI technologies, systems that are in use or that you are about to develop. As I said, it's a principle-based framework. It's based on 5 principles: safety, transparency, fairness, accountability, and contestability and redress. I will go through those principles when I come up with suggestions how to apply the framework. It's non-binding, it applies across sectors, and there are no strict rules, and so far also no financial penalties if you are not adhering to the principles. There is also no AI-specific enforcement or supervisory regime in the UK. There are some key regulatory bodies. I named 4 here on my slides on the right side. The task of those regulatory bodies is to interpret and apply the principles that are stated in the white papers to the development and use of AI within their domains. I assume if you process personal data, all of you have to look at the Information Commissioner's Office guidelines on AI practices, but also data protection. I have some slides which I go in later on. So those regulatory bodies that I mentioned here, Ofcom, FCA, MHRA, and the ICO, have provided some guidance where they apply the principles stated in the white paper. However, keep yourself informed, because so far it's only some guidance. As I said, it's not completely worked through yet, and as AI is developing, I assume that those regulatory bodies also will come up with more and more guidance requirements that you need to adopt. AI systems are categorized into 3 types. As you will see here on this slide, there is no formal definition of AI. AI systems in the white paper or AI technologies are defined as products and services that are adaptable and autonomous. And in the UK, we decided, or the government decided, not to have a clear definition, because the development is so rapidly within AI and AI systems that the decision was a definition would narrow it too much down and not take care of future developments. However, the white paper defines 3 types of the most powerful AI systems to ensure proportionate regulation throughout those key regulatory bodies and that address some risk and capabilities effectively. So starting with the general purpose AI, GPAI. Those are versatile models with expert or superhuman abilities across tasks. Those technologies and systems, they aim to replicate human intelligence and perform tasks. I mention Google DeepMind or Palm 2 as an example. This is a powerful language model for reasoning, coding, and translation. They currently face the least clear legal responsibilities, but they also present some of the greatest potential risk to human rights, such as deepfake. Moving forward to the next one, it's highly capable narrow AI systems. Those are specialized models excelling in specific fields, for example, biology, with superhuman human performance. If those systems present potential danger capabilities, there is a different set of interventions required. So those narrow AI systems are designed to perform specific tasks. This could be a chatbot. And here I mentioned the principles earlier, especially the transparency principle will become important here to take care of. Agentic AI are systems or technologies that autonomously completes multi-step tasks over time using various tools. And I think Amazon Alexa is one of the most known here. Those systems and technologies raise questions around how AI agents remain iterable, ask maybe for approval before taking action, and how they can be interrupted. So by categorizing AI systems into GPAI, narrow AI, and agentic AI, the UK aims to support responsible AI development while encouraging innovation. So as a business, you need to comply with any sector-specific regulation once introduced by those relevant regulators that are taking care of your industry sector. If we have a look at the outlook aims of the current regulatory UK framework, as I said, it's a flexible approach, it's a non-statutory adaptable AI framework, and those 5 key principles you need to take care of are safety, security, and robustness, meaning AI systems should function in a safe, secure, robust way. They should be reliable and threat resistant. Here you need to take care of cybersecurity issues. You should implement risk management and also adhere to technical standards that will be the requirement by the regulatory bodies. Next, AI systems should be appropriate, transparent, and explainable. Those users and need to understand what is going on. Fairness is also a very important principle in order to prevent bias and discrimination, especially AI systems should not undermine legal rights. Accountability and governance, you need to define oversight and responsibility, who is accountable if something goes wrong, and then contestability and redress. Users should be able to challenge AI decisions, so they also need to have a contact person. If we look at the implications of the EU AI Act on UK business, so let's move forward. As I said already before, the EU, decided to take a completely different approach. Here we have horizontal legislation, and the EU AI Act is a special law which obviously exists next to other laws like the EU General Data Protection Regulation, competition laws, etc. So the EU AI Act governs 2 issues. First, AI systems. These are software with varying autonomy that generates outputs, for example, predictions, recommendations, and which influence physical or virtual environments, potentially adapting after deployment. Then there are also general purpose AI models mentioned, and those are, as we explained before, versatile AI technologies and systems that are capable of performing diverse tasks and integrate into various applications, so human interference, etc. The EU has chosen to have some definition, which are also broad, but it's more narrowing AI systems and AI technologies down. The scope of the EU AI Act is that AI obligations depend on classification. So the EU has chosen to classify risk. Some of the technologies and systems are prohibited. Then there are some classified according high risk or individual user facing AI. And depending on what level of risk the system is categorized into, the obligations are higher or less stringent. There are also some scope limitations to the application. It's not applicable to areas outside EU law. For example, national security is not regulated in the EU. The AI Act excludes also military and defense applications or purely scientific and research and development. And then non-professional AI use is also not covered. What is important for you in the UK is that the AI Act has an extraterritorial scope, which we see on the next slide. Here, oh, sorry, I was a bit too far. It has an extraterritorial scope, but I will explain that a bit before. So the application of the EU AI Act, there are certain roles also covered by the AI Act. The roles in the next slide are described in the slide. The AI Act applies to different actors and different ways. Let's start with the providers. A provider is a company that develops AI-based software, for example. Could also be that it is developed on their behalf, but let's assume we have a provider developing AI-based translation software. So as a provider, the provider is responsible for the compliance of the softwares with the AI regulation, with the EU AI Act, including the safety and transparency of the AI algorithm. The importer could be a company that imports exactly this software from a third country into the EU. So the importer must check whether the software complies with the EU AI Act before it's offered on the EU market. So if you're dealing with an importer located in the EU importer needs to make sure that the AI system or technology is complying with the EU AI Act. Then the Act mentions distributors. Those are companies, for example, an online shop who is selling the software, and this distributor needs then inform buyers of all relevant information regarding complaints with the AI Act. Last but not least, we have deployers. Deployers could be an agency that uses the software to translate, for example, text. And as an operator, the agency, the deployer, must ensure that the use of the software complies with the requirements of the AI regulation. So looking at this, mainly important is providers and deployers, because here we have the extraterritorial scope that is placed by the EU AI Act on business. We see on the next slide that, for example, a provider, so those parties who are developing AI systems and AI technologies, they need to apply the EU AI Act regardless of their location. So if you are a provider of an AI system or AI technology, you need to make sure that you fulfill the obligations of the EU AI Act. If you are a deployer, for example, in the UK, and this AI system or AI technology has outputs which are used in the European Union, like predictions, recommendations, you also need to be compliant with the EU AI Act. As I mentioned before, the AI Act has a risk-based approach. According to the AI Act, AI systems or technologies can be categorized into 4 risk categories. There is an unacceptable risk, and if the system falls within this area, it's actually called a prohibited AI practices and may not be placed on the market. If it has or is assumed to have high risk or imposes high risk, there are quite huge obligations. Then there are limited risk, there is less to do, and minimal and no risk, and then it's outside the scope of the AI Act. The AI Act has an annex, which is actually listing quite a lot of examples where you can see whether your system used or developed falls within one of the categories. And if we look on the next slide, I have tried to use those risk categories and show you some examples. So we have forbidden AI systems, and forbidden AI systems are completely prohibited on the EU market. And those are all systems or technologies that are used for behavior manipulation. For example, social scoring, influencing behavior, especially of those in need of protection. Harmful AI-based manipulation and deception, that could be an example. Individual criminal offense risk assessments or protection are prohibited on the EU market. Technologies that impose a high risk have high technical and organizational standards. They can be used in products subject to EU product safety regulations, for example, medical devices, certain vehicles, aviation, lifts. It could be those listed in security components and critical infrastructure, etc. If you use or develop an AI system that is categorized with high risk, this is subject to comprehensive regulation, including obligations. So this could be systems that are used for scoring of exams, AI applications in robot-assisted surgery, credit scoring, denying citizens opportunity to obtain a loan, or a solution to prepare court rulings. The obligations are that you definitely have to implement risk assessment, that you mitigate systems, that you have a high quality of data sets that are feeding the system to minimize risk of discriminatory outcomes. You need to log activities to ensure traceability of results. You have to have detailed documentation in place, providing all information necessary of the system and its purpose for authority to assess its compliance. Then you have clear and adequate information in place to the deployer. You also need appropriate human oversight measures and high level of robustness, cybersecurity, and accuracy. So these are the obligations that the AI Act implies on high-risk AI systems. Then there are some systems that are categorized having low risk. This could be, for example, AI chatbots. If you implement an AI chatbots, you actually only have to deal with transparency obligations. You need to communicate to users what kind of system is used, how it is used, what data is used, etc. And then there are AI systems with minimal risks, and this could be AI in computer games or AI supported spam filter. And if you use a system or develop a system that falls within this category, it does not fall within the scope of the AI regulation and are therefore not subject to any restrictions. But I can only recommend to look into the annex of the AI Act to see the examples and to evaluate whether your system falls within one of the categories or within which category. Lastly, we have financial penalties imposed by the EU AI Act, and they are expected to be very significant. The EU AI Act came into force last year. There's still a transition period, which is expiring more and more already this year. So I cannot tell you any fines that have been imposed yet, but look at it. If you do prohibited AI practice within the European Union, you engage in banned AI activities, that can result in fines up to 35 million euros or 7% of the company's total worldwide annual turnover, whichever is higher. We know this from the GDPR already. It's the same in the UK as in the European Union. Here we have still the same laws in both regions. If you do not, or if you fail to meet with obligations of the provider as a provider or other party, then you can also be subject to fines that might lead up to 50 million or 3% of the total worldwide annual turnover, again, whichever is higher. If you supply false, incomplete, or misleading information to authorities, to users, etc., you may incur fines up to 7.5 million or 1% of total worldwide annual turnover. Again, which one is higher? And you see the fines are really high. What is also important to know, we have, or there will be established national supervisory authorities in each member state. They are coordinated on an EU AI board. So they have a coordination platform and advisory body for the EU Commission. And the AI office within the European Union Commission is also in charge of overseeing the enforcement of the AI systems for general purposes. It's quite similar to other sectors like data protection, competition law, etc. But the question remains, obviously, who is overseeing it within the company? Could be the data protection officer, the compliance officer, etc., because someone should monitor within the company how the act affects your business. So let's move forward to AI and data protection law. When you develop or use AI systems as a UK business, you definitely need to adhere to the UK GDPR. The ICO provides very comprehensive guidance on aligning AI practices with data protection law already. You need to know the principles that apply to you when processing personal data. So once an AI system or technology is processing personal data, first of all, ask yourself, do I have a legal basis at all to process the personal data? Can I apply the fairness principle, prevent bias and discrimination to protect individual rights? It should not be hidden processing taking place. Have you taken care about the transparency principle? Is it clearly communicated to data subjects how AI is using data and how it is provided to other parties? What is the purpose? Is there a third country data transfer? So is it transferred outside the UK? And if AI is used for automated decisions, you also have to explain how automating decision is taking place. So make sure you have fulfilled the transparency requirements. There is a principle of purpose limitation. You need to have a purpose, a clear purpose defined before you use the AI system or technology, and make sure you have documented it. For example, in your records of processing activities. What is your intended purpose? And is it clear before the data processing begins? How about data minimization? Have you made sure that you only use the data that is needed to achieve the purpose? Is the data accurate? Have you ensured data quality? And can you make sure that there are precise AI outputs to maintain integrity? Then storage limitation. Big issue all the time. Do you delete the data at one point? When are you deleting the data. You also have to make sure that you inform the data subjects about storage limitation. So have clear timelines in place for data retention and deletion, and make sure that you have established this. And a huge principle in the UK GDPR is accountability. Make sure if AI systems or AI technology is processing personal data, that everything is documented, that you uphold those data protection principles, that you can show, especially the ICO, in case there are questions, in case there are data subject requests, in case there's a data breach, that you actually have considered all those principles in your AI systems and technologies. Maybe you even have to conduct a DPIA, a data protection impact assessment. Make sure that you look at the list of the ICO when you are required to do a DPIA. Make sure that you know how to do the risk assessment and for what kind of technology and systems. So my recommendation is that when using AI systems and technologies, because most of the time those systems and technologies process personal data, that you involve your data protection team at the early stage. Good, I promise to give you some practical solutions for compliance and accountability. First of all, understand and monitor regulatory requirements. Stay updated on the UK AI regulatory framework, including proposed AI-specific legislation, because at this time, it is not clear whether the UK will remain the framework, the sector-specific framework, or will implement a legislation like we have it in the European Union. The tendency at the moment is going to the sectoral approach, to a non-binding approach, but there is a huge discussion in Parliament. Familiarize yourself with the ICO's guidance on AI and data protection, and also the ICO's AI and data protection risk toolkit. So here you can actually, they have provided a nice Excel list where you can provide a risk assessment of your AI systems and technologies. The ICO is at this stage the only regulatory body who came out with risk guidance, which is already very structured and very clear. All the other regulatory bodies, they are still working on more comprehensive guidelines. Then also consider whether the EU AI Act is affecting you, and if, make sure you are compliant if you're operating in the European Union or the European Economic Area. Make also sure that you keep track of international AI laws like the US AI regulations if you are operating globally. I said in the beginning, the AI environment is changing so fast, so also the regulatory approach this will change a lot. So if you are using AI systems or you are developing AI systems, remember I mentioned the 5 principles in the beginning. Now I will go through those principles a bit more detail and come up with examples what you should do when using AI. I mentioned in the beginning, first principle is on safety, security, and robustness. So consider the impact of AI on security. Have you implemented robust cybersecurity measures to protect AI systems from misuse or breaches? Are you employing privacy enhancing techniques? For example, is data minimization taken care of? Is your staff trained and be alerted and also skeptical? Let's just take ChatGPT as an example. Is your staff trained to check the results and skeptical towards it? because often there are also bias here, and you still need to make sure that the results are correct. Second principle, ensure appropriate transparency and explain what the AI system is doing. So provide clear and understandable information about how AI makes decisions and how personal data is processed. Ensure also that the AI-assisted decisions are explained to users and also to regulators. Implement user rights safeguards, including options for human intervention where required. So don't rely just on the AI system or technology. And I always recommend to work within customers' realistic expectations. Let's move to the third principle. The third principle is on fairness. Ensure that you really use high standard of data quality in order to minimize bias. The AI models should not discriminate against protected groups, for example, children, the elderly, etc. Make regularly audits on your AI systems. So remember to include AI systems in your yearly audits to identify and mitigate biases. And make sure human review takes place and don't rely only on your systems. The fourth principle, implement strong AI governance and accountability. First of all, I would check whether the use of AI is necessary at all. Maybe you need an AI compliance officer, depending on how many you use, how many systems and technology you use. But definitely you should integrate AI in your risk management, for example, in your existing data protection or information security structures. Most probably you need to conduct a data protection impact assessment for AI-related projects, but here I again like to refer to the ICO's website. They are providing really good guidance on this. Within the company, do you have clear policies for AI development and deployment? Do you ensure alignment with legal obligations, copyright law, other intellectual properties, consumer competition laws, etc.? Do you actually have an inventory about your AI systems and technologies used? And make sure training and awareness is not forgotten. The fifth principle on contestability and redress asks you to have a clear, accessible point of contact for all actors in the AI lifecycle. If a business contact, a consumer is complaining, who can they go to? Could be the data protection officer or the data protection contact person. You should definitely have a single clear point of contact or mechanism for users and other affected parties to seek redress for adverse outcomes. You should have processes in place for challenging outcomes and processes for correcting data. Make sure that you have guidelines, regulations in your company to use AI systems and tools in an appropriate way. Last but not least, assess the legal basis and data protection compliance. Do not forget AI in your data protection management system. Identify appropriate lawful basis. Often you have also service providers who are using AI in their tools that you may use, in your softwares that you may use. You might have an electronic system for your HR department where you have the personal files. They are using more and more AI tools when they develop those tools, when they enhance those tools. but are they allowed to use your personal data to do so? Make sure that you look through the data protection agreements whether this is covered. So ensure the principles, ensure compliance with the principles, as I said, fairness, accuracy, minimization, data security, etc., and implement measures to protect sensitive data and prevent AI bias. Yes, thank you very much. That was what I have to say so far. And I think we can receive questions if there are any.
Yes, and thank you very much, Evelyn. Before we move to the Q&A, we really appreciate your time and such an insightful session, and of course something that's incredibly important at the moment. So we thank you very much for your time and your presentation today. We have a bit of time now for questions in from the audience. So if you do have a question for Evelyn, please do send that in. And we will try to get that answered for you. I have a first question here from Michael, who says, even if regulations are implemented in the EU and UK, do you feel the more open stance of the US and other countries will mute them?
Well, at the moment, it's a very early stage, but the problem with the EU AI Act is obviously that it's quite an administrative burden for companies to comply with those obligations. You need to document, you need to look, you need to make assessments, you have to have risk assessments, etc. On the other side, I think it's also good to have standards to know what you have to comply with when you are developing, for example, an AI system or software. So it's the same for each sector, and not like in the UK, I have to look into, okay, what is the regulatory body I have, which requirements do I have to fulfill, etc. So there is a downside of both systems, but also advantages in both systems. And we'll have to see what is going on and how the market is reacting, especially to the EU AI Act. It's quite an early stage yet.
Excellent. Thank you very much, Evelyn. As I say, please do, if you have any questions, a fantastic opportunity now to have that answered by our expert, Evelyn. We have a question here, and I guess you may have covered this throughout the presentation, but it might be good just to reiterate. The question is, will the enacted UK AI Act cover all relevant data protection challenges, or will there still be unattended areas?
Yeah, so data protection and AI, this is really difficult. As I said, lots of systems, especially within the employment HR sector, are obviously very useful, but they process personal data to quite extent. So you need to look into the systems. To what extent is it allowed? And also remember, the ICO is a very, in my opinion, very strict authority on data protection, one of the strictest, I guess, together with France. And even though you do not have fines in the AI regulation that is in place, or those guidelines that is in place, the UK GDPR imposes very, very high fines. So each time you process personal data with AI systems and AI technologies, you need to be compliant, because if not, you face high risk. Data subjects could complain in case of a data breach if you cannot show accountability that you have documented, that you have taken care about data protection principles. This can go very, very wrong. And but on the same time, it's a huge challenge to comply with the UK GDPR when using an AI system, because you need to have the legal basis. And you have to make sure, take a chatbot, that's easy. You can ask for consent. Do you want to use a chatbot on my site? Yes or no, that's easy. But what is going on at the moment as well are systems that or software that you employ to look at the data quality, at the calls with your customers, for example, and it gives you emotions are popping up, telling you, oh, your customer from the voice recognition does not feel very comfortable with you, etc. And the question is this allowed to use at all? Because how do you want to do it? You're processing personal data. So actually you have to ask the customer beforehand, is it okay that I'm using such software to improve the quality of this call? But is it still transparent? Is it fair, etc.? So I think there's a huge challenge being compliant with data protection when using AI systems.
Yes, Evelyn. And do you have some concerns, I guess, looking ahead at the next year, the next 5 years, with companies becoming compliant?
Those companies that are compliant with data protection regulations shouldn't face huge problems with being compliant with the AI when processing personal data. But I think business who are developing AI systems and AI technologies, they have a huge burden complying with the AI Act. And if maybe moving to the question here in the chat,
Yes.
the UK really tries not to have a horizontal approach like the EU. So far as I am informed, they stick to the sectoral approach. But again, it's an early stage. We have to see how the different regulatory bodies are reacting. Are they going the same direction? If you are in two sectors, you might have to deal with two regulatory bodies, but we have the same problem in the European Union because yes, there should be an AI regulatory body in every EU member state, but it's not really happening yet. So, and then they are, for example, take Germany as an example. We have already in Germany 16 different data protection authorities. So will there be 16 different AI regulatory authorities as well, depending on the federal state you are in? Or should it be with the information security officer? We have one federal officer for this. There is still a discussion going on. So it's a very early stage. In the UK, that definitely do not want at the moment to have the same approach like the European Union, but maybe you are still forced to have a regulatory approach. We will have to see, and we have to be, yeah, we have to watch what's going on. Keep yourself updated.
Thank you, Evelyn. And we've just had another question in. When buying an off-the-shelf AI system for the likes of medical diagnosis, how can you be sure about the information provided by the developer? And the questioner says, I have come across unfathomable support information that becomes hard to interrogate.
Yes, so see that's the advantage of the EU AI Act because the Act states clearly what you have to do. In the UK, we have the principle of transparency, but who is enforcing that a company is actually doing it? So if it's medical diagnosis, we have to look at the regulatory body who is in charge for such systems for this market, and we have to see how they enforce it because if it's just soft law, it's very difficult to enforce. You can enforce soft law. It's mainly the reputation then. You can give warnings, but there are no fines yet. On the other hand, if this system for medical diagnosis will definitely process personal data, because if it's your health, there is health data, so the ICO would be, for example, the authority where you could go to and complain, and the ICO is required to take your complaint very, very serious, and they actually do this, and they will approach the company and say like, hey, there is a complaint. Why have you not done it how it is according to the law?
Excellent, thank you, Evelyn. And I think that answers the question brilliantly. We still have 5 minutes, so if there are any questions, you can send them in now. But Evelyn, I'll just ask you now with sort of 4 minutes to go, if you have any closing comments or anything that you want to say now before we finish, I'll hand over to you for any of those.
Well, it's a very interesting environment, I guess. AI is developing very fast. We have changes all the time. There are new products on the market which can be very useful. But I think most important is training and awareness of the users. Make sure your staff understands how to use it. Be aware because cyber criminality is arising or is using AI as well. Phishing mails are becoming more and more sophisticated. So make sure that your staff, when you just use AI systems in your company, is aware of how to use them, have clear guidelines in place, which systems are you allowed to use in a company, which systems should you not use, etc. Also make sure there are a lot of free versions of AI software that make sure that here, let's take ChatGPT. If you use the free version, ChatGPT has the right to read through it and use the data to to develop the systems. If you pay for it, you are much more safe in terms of data protection, information security, because here you have a clear contract with ChatGPT on how they use the data, etc. So open, free versions always come to another price. Remember this.
Thank you, Evelyn. Well, I think that's a fantastic place to end today's session. So thank you so much, Evelyn, for your insights and expertise. It's been a pleasure to spend an hour in your company this morning. We do encourage you to please get in touch with Evelyn with Active Mind Legal for any inquiries that you might have. But thank you very much to our audience for being with us as well. We really appreciate it. Evelyn, I hope we can have you back again soon. But for now, have a lovely rest of your day, everyone. Thank you and goodbye.